So let's proceed to the next topic, which is authority of the partners to bind the partnership. So when the partnership is dissolved, so the authority is also terminated. So general rule, all authority of the partners to bind the partnership is terminated, meaning wala po sila dapat gawing any transaction kasi nga 'di ba all of the authorities of the partners is terminated. If they do so, okay, that the those transactions or events happen during, okay, the solution of the partnership is not binding to the partnership, meaning there's no liability. Hindi po magiging liable si partnership. But that's general rule. So there is an exception. Okay, exception, you can do any acts necessary to wind up the partnership affairs, okay, to wind up, to liquidate, okay, and any acts necessary to complete transactions begun but not finished. Ito, so nasimulan mo yung transaction na yan pero hindi natapos until such time na nag-evolve or nag-occur ang dissolution. So what are the qualifications? So we have here, with respect to the partners, if the dissolution is not caused by any act, death or insolvency, okay, of a partner. So the authority of the partners to bind the partnership by new contract is immediately terminated. So if the reason of the dissolution is hindi, okay, by the act of the partners, death of a partner, insolvency of any partner, okay, or insolvency, ayon. So the the authority of the partners to bind by new contract is immediately terminated, meaning hindi po liable ang partnership. Okay? Ayan. Next, if due to ADI or if the dissolution is caused by act, death and insolvency of the partners, authority of the partners inter se to act for the partnership is not deemed terminated. So each partner is liable to his co-partners for his share of any liability created by any partner acting for the partnership as if the partnership is not dissolved. Okay, so we have exceptions here. So if the cause of dissolution is the act of the partner and the acting partner have knowledge of such dissolution, and if the cause of dissolution is death or insolvency of a partner and the acting partner had knowledge or notice of the dissolution. So as mapapansin ninyo sa exception, may knowledge sila pero pinagpatuloy pa rin nila yung transaction. Okay? Ayan, so we have example for this. So here is the summarized figure of what is discussed a while ago. So the authority to enter into a new transaction. So the authority of the partner is terminated if not by aid. So ayun yung ano yung aid, acts, insolvency or debt. So hindi po siya caused by any of these acts, insolvency or debt. So example, expiration of the term for which the partnership was constituted or by decree of court. So this is not a dissolution caused by aid, okay, or acts, insolvency or debt. Therefore, the authority of the partner is terminated. Now, what if the reason of the dissolution is due to aid or acts, insolvency or debt? Okay. So ayan, plus the partner had knowledge of the dissolution. So what will happen? Ayun, authority is still terminated. Okay? Ayan, may knowledge kasi 'di ba? Yung partner, pero pinagpatuloy niya pa rin yung new transaction na yan. So again, the authority is terminated. So what will be the result? The partnership is not liable for the whatever, okay, liability it may arise. Ayan, the partnership is not liable. So what if it is caused by aid, but the partner had no knowledge of the dissolution? So here, wala siyang knowledge, pero yung partner continues to transact, okay? So the authority here is not terminated. Therefore, the partnership is bound. In other words, the partnership is liable. Ayan. So next is with respect to third persons. So the partnership is generally bound or liable by a new contract although authority of the acting partner is already deemed terminated, but the innocent partners can recover from the guilty partners. Okay? Ayan. So we have another situation here. When the partnership is bound to third person even after dissolution. So after dissolution, the partnership is still bound, meaning the partnership is liable if ito yung magiging reasons, okay, for the new transaction. Transactions in connection to winding up of partnership affairs, so pwede. So the act is, the authority is not terminated if it's in connection to winding up of affairs. Next is acts for completing unfinished transactions. Okay, again. So kapag may mga transactions or contracts na hindi natapos, okay, and then at the same time, nag-dissolve yung partnership, then pwede siyang tapusin. Okay? Next is any transaction which would bind the partnership if dissolution had not taken place provided that the other party is in good faith. So yung third person is in good faith. Meaning, if we have previous creditor, he had no knowledge or notice of the dissolution. So wala siyang knowledge, wala din siyang notice na dissolve pala yung partnership, na involved siya. Okay? Another, not a previous creditor, so therefore, he is a new creditor, and the fact dissolution had not been published in the newspaper of general circulation. So, here, it's a new creditor. So, a new creditor, before kasi siya mag-enter sa contract to any of the partnership, diba? There is a rule na dapat siguraduhin niya na okay yung kakontratahin niya partnership or company or business enterprise. So this will never uh, will never give him the right to pursue his rights, 'di ba, in collecting the debt if ever okay hindi niya alam na dissolved na pala yung partnership. Okay? Ayan. So, not a previous creditor in the fact of dissolution had not been published in a newspaper of general circulation. Okay? So, another, when a partnership is not bound, here's a situation na to, the partnership is not liable to third persons after dissolution. When there is this dissolution due to unlawfulness, okay, when there are unlawful events, ayan, hindi na pwedeng magiging liable si partnership. Aside from that, when the acting partner in the transaction had become insolvent, so hindi pwedeng magiging liable si partnership. Yan. And where the other partner is unauthorized to wind up the affairs except by transaction with one who is a previous creditor and he had no knowledge or notice of the dissolution. Okay, and not a previous creditor, and the fact that of dissolution had not been published in the newspaper of general circulation. So I know that is really vague for you, so let's have a figure for you to fully understand this one. So this is the summary of the previous slide that I've shown to you a while ago. So the act of the partner after dissolution binds the partnership, meaning the partnership is still liable if there is winding up of affairs, completion of unfinished transactions, and new transaction. But here, new transaction, kailangan muna nating identify if it is a previous creditor or a new creditor. So kapag previous creditor, we really need to notify the creditor para hindi magiging liable si partnership. Okay? A mere publication of notice is not will not suffice or will not suffice. Okay? So here we are required kasi that if the partnership will be dissolved, kailangan nating mag-post sa general circulation ng news that this partnership or establishment is dissolved, okay, for the public information. So, if hindi natin yan na accomplish, then we will be liable to the previous creditor. Okay? So, halimbawa, hindi natin siya na-notify, pero the previous creditor read the publication that is equivalent to constructive, okay, information. So therefore, kapag alam na, the moment na nalaman na ng previous creditor na dissolved na pala yung partnership, Okay, hindi na magiging liable ang partnership. So in other case, so without such notice or knowledge, the partnership will be bound or liable by the transaction to the previous creditor. Now here, in the new creditor, okay, the new creditor is not entitled for special attention. So, a mere publication is a constructive notice to him. So, the moment na makita niya sa publication, that is, he will be bound by the dissolution na. Meaning, hindi na magiging liable si partnership. Okay? Pero if ever hindi nag-publish talaga yung dissolved partnership which is required by the law, so the new creditor is not bound for the dissolution. Meaning, magiging liable si partnership. Okay. So here, act of a partner after dissolution but does not bind the partnership, meaning it will not hold the partnership liable if there is unlawful event, the acting partner is insolvent, the partner had no authority to wind up the partnership affairs. Pero may exception tayo dito, exception to number 3, if kapag previous creditors yung katransact natin, kapag walang knowledge or notice, the partnership is still bound or liable. Okay? Ayan. So, to protect the innocent third person. Actually, nasa taas siya. Itong naka-blue one, without notice and knowledge. Okay? Next is the authority is terminated and the third person had actual or constructive knowledge. So, kapag may constructive knowledge na siya, ayan, yung third person, hindi na magiging liable yung partnership. Okay? So, that's what it means. So we have here an example. So let me read it to you. Madrid, Acosta, Platon, Lovina, and Espino are partners in Maple Enterprises, which is engaged in trading of dry goods. So Madrid is the manager. Espina dies. So by that reason or event, there is a dissolution occurred. But here, Madrid knows the death of Espina, but he still purchases the goods from Romero, a creditor who had granted credit to Maple before dissolution. So Romero was not aware of the dissolution of the Maple Enterprises by reason of the death of Espina. So here, in this statement or problem, since Madrid knows of the death of Espina, then his authority is already terminated among the partners. Kasi nga, di ba, may knowledge siya pero pinagpatuloy dyan pa rin niya. Okay? So, with respect to Romero, who is a previous creditor here, since he was not specially notified by the dissolution, now, anong magiging effect? Maple is bound or the partnership is bound by the purchase made by Madrid. So meaning dahil walang notification at wala din siyang knowledge, Romero is still an innocent third person kasi need kasi siyang i-notify. Okay? So ayan. So, magiging liable pa din si partnership Maple. Okay, in this case, Romero can go after the assets of Maple. If Maple assets is not sufficient, let's say, kulang, then he can go after the separate assets of all the partners. Ganun siya, di ba? Okay, so including those of Espina. Thereafter, Acosta, Platon, Lovina, and the legal representative of Espina, kasi patay na si Espina, can go after Madrid for the damages, indemnification of damages. This is so because among the partners, Madrid's authority to enter a new transaction was terminated by reason of his knowledge of the death of Espina, pero pinagpatuloy pa rin ni Espina. So how about, same situation pa din, but if Madrid was not aware of the death, now kanina, aware siya. Ngayon, let's have this situation na wala siyang awareness, okay, as to the death of Espina. Then his authority was not yet terminated. So, among the partners. So, accordingly, he can call on his partners and on Espina's legal representative for the contribution from the partners' separate assets if Maple assets are not sufficient to pay the liabilities. Okay. The partner shall be liable as if Maple has not been dissolved. So, kailangan talagang magbayad ni Maple. So, if hindi pa din enough yung assets ni Maple, then Romero can go after the separate assets of the partners. Kasi hindi na terminate yung authority ni Madrid doon kasi wala siyang awareness or knowledge. So, again, another situation, with respect to number one, okay, what if Romero was specially notified of the dissolution? Okay, na-notify si Romero, who is the creditor or the previous creditor. Then only Madrid will be liable to Romero. So Madrid cannot call on the other partners and Espina's legal representative to share in the payment. So here there is no partnership liability. So ang magiging liable lang is yung nakipag-transact. Okay? Ayan. So who is Madrid? Another pa na situation. If there was a publication of the dissolution but Romero has not read it. Okay. So again, Romero is a previous creditor. So kailangan siyang ma-notify, hindi need or hindi enough na merong publication. So let us continue the reading. So Romero has not read it. Romero as a previous creditor is deemed to be without notice or knowledge. Accordingly, Maple is liable pa din kay Romero. If Romero is a new creditor, Maple will not be liable. But here, he is a previous creditor, so magiging liable pa din siya. Okay? So again, if new creditor si Romero dito, Maple will not be liable to him because he is not entitled for a special attention. So the mere publication of the dissolution of Maple is sufficient notice to him. Okay? That's the end of our topic.